Hello, and welcome to another of our short teach-ins here at the Tenant Farmers Association. My name is George Dunn, and I'm the Chief Executive of the Tenant Farmers Association, and pleased to be your host today. This teach-in is part of a series which seeks to shine a spotlight on topical issues being faced within the tenanted sector of agriculture. It's part of a growing YouTube library, which also features webinars and important industry updates. So don't forget to let us know your thoughts in the comments below. And if you find this video useful, why not subscribe to our channel so that you don't miss out on any new content. Today, we're going to hear from Adriana Vaux-Chan. She's an expert rural surveyor here at the TFA, and she will be highlighting the risks involved in unwritten partnerships. But before we start, I'd just like to say that we're delighted that Roy Thorne's solicitors are sponsoring our 2025 virtual teach-in sessions. For those of you who don't know who Roy Thorne's are, it's a national firm steeped in agriculture. They have 90 years experience advising tenants and landowners alike. The lawyers are active in farm tenancy policy groups, so they do get the bigger picture. So whether it's about a succession application under the Agricultural Holdings Act, or a new farm business tenancy, a dispute with your landlord, a share farming agreement, or a collaborative natural capital agreement, Roy Thorne's is there to advise and assist. So on to today's teach-in, which is understanding the risks involved with unwritten partnerships. Now, this is being recorded in the summer of 2025, so everything we cover today is correct at the time of recording. So for advice on your individual circumstances, we do recommend that you call TFA head office in order to speak to one of our team of advisors like Adriana. So I'd like to introduce you now to Adriana Vaux-Chan, who is one of our specialist rural surveyors, as I said. Welcome, Adriana. Over to you.
Good morning, and thank you, George, for your introduction. As George alluded to, today I'm going to be speaking about the risks of unwritten partnerships. And as you probably are aware, partnerships are the most common arrangement in farming because they are not only flexible, but they are very easy to set up. In fact, often so easy to set up that no one actually puts them in writing. So they are popular for both succession and tax planning. However, there are many risks amongst around, and which the largest is not having a written partnership. So as soon as parties, often families, decide to farm together and act like a partnership and set up a bank account, it then becomes an unwritten partnership agreement. And the risk associated with this is great. Firstly, there's no bespoke division of assets, which means that parties, there's no way of defining who gets what or who owns what in terms of the asset. So if everyone brings in different assets to the table, there's no differentiating who gave what clearly in the document. And there's also no easy way of dealing with breaches within the partnership. So if a party were to not act honourably, or if they were to do something which was against the partnership, there would be no easy way of resolving this without dissolving the entire partnership. Whereas if you had a written agreement, it could be written specifically how breaches were dealt with. Also, there's no easy way of removing a partner from the partnership agreement without dissolving the whole partnership, which again would be disadvantageous if some of the partners wanted the partnership to carry on and just remove one partner. An unwritten agreement solely relies on the Partnership Act of 1890, which instead of being very suitable and specific for each party and business, just provides a really generic way of dealing with things, which often isn't in the best interest of either of the parties. There's quite a handy piece of case law, which is the Miles v. Clark 1953 case, which really does highlight the importance of having a formal partnership agreement, and shows that evidence in partnership business is vital in order to show who owns what asset, where the assets were jointly brought in, and how they should be treated. Because without a written agreement, partners can lose control over how matters are applied, and this is when evidence becomes crucial. Thank you, Julia. Next slide. So when drawing up a partnership agreement, it's really important that firstly, it's done properly by way of a solicitor. And secondly, that all the parties come together, sit around the table first to decide where they want their business to go, what part they want to play within the business, who owns the assets, what are the assets, and then really everyone is then singing off the same page. This is a list of heads of terms which I put together just as an example of the types of categories which should be put within a partnership agreement, such as business type, dairy, arable, whatever it is. The parties identifying clearly who they are. The term of agreement, you need to think about the return on investment, responsibilities, which are the roles and times which each partners spend. So, for example, it might be that there's more of a silent partner, someone who's retiring, and the younger generation is spending more time on the farm. So this needs to be reflected within the agreement and potentially in terms of the profit they get from that. The day-to-day decisions, so who actually makes them. The daily operations, so who's carrying out the day-to-day work, what are they doing, and how are they doing it. Any sort of tax liability, business debts, and what are they? So identifying exactly what those business debts are. They hire purchase of equipment, future funding, where will that come from? Does business need any grant funding? And then you need to identify drawings. So who's going to be getting what? They don't necessarily need to be equal. So for example, you could have mother and father who have been in the partnership a long time and want to bring their daughter in, so that the daughter would then have a lesser share. So it doesn't have to be equal. And this is a good way of starting off bringing a new person in. And then it's really important that the business, everyone is following the same business value. So for example, it might be that they want to save it for the next generation rather than farming more commercially. So that might be the value of the business. And this sort of links in with farm policy. What's the farm ethos? Is it an organic farm? Is that what the family want to work towards? So that becomes the ethos of the farm. And that's also very helpful to have that within the partnership agreement, so that all parties know which direction they're going in and what is expected. Business costs, are there any costs which partners will need to sort of put money in to help the business out? So that needs to be documented. And really importantly, using the land, what are the repairing obligations of the holding? It might be that there is some owned land as well as tenanted land, and that needs to be featured into the repairing obligations of the owned land if that's going to be a partnership asset. And really importantly is the capital input. So what actually is being put into the holding in terms of the assets, land, livestock, dead stock, all sorts of things that are put in. So that needs to be detailed. And then going to grants, if the partnership is going to be applying for grant, should be documented where that money is going. And another important one is dispute mechanism. We touched on this a bit earlier, but if there is a dispute within the partnership, how is that dispute going to be settled? It could be court or arbitration, mediation. There's a few methods which need to be thought about. And then finally, termination. So without the whole partnership having to be terminated, without the partnership having to be terminated completely, it could be that one person leaves, or it could be that you want to terminate the whole agreement, and then how assets are split up between that. So these are just a few of key heads of terms which can be and should be incorporated into a written partnership agreement. And if members do want any further ideas, then please do contact us advisors, and we can certainly talk through that with you. Thank you, Julia. Next slide. So as you can probably see from now, there are many benefits of having a written partnership agreement. It just means that people who can get a real fair profit and loss share between the between the partners. So that essentially means that if someone is putting more into the business, they can get more out rather than everything being split equally. It enables and encourages partners to reinvest into the business. Because they know exactly that if they put more in, they get more out. It's flexible, which enables new partners to come in with the ability to increase shares later. It should be noted that it's really vital that partnership agreements are always kept up to date. Once you have one drawn up, it doesn't mean that you never need to revise it. It actually is really crucial to keep updating it so that it always goes with the flow of the business, changes if people wish to retire, or if you wish to bring new people in, or if you need to reduce the level of shares within the business. It's really important that you continually revise it and check that it's up to date and serves its purpose. It's totally customizable, so you can pretty much write anything into it. So it could be that one person passes away and you want a purchase option so that the remaining person can purchase things. There's an easier dispute mechanism channel other than relying on the Partnership Act. Unlike a company, there's no need to submit accounts, which also is quite helpful because it's one less administrative task. And then it really enables flexibility for succession and tax planning. We see a lot of people who are wanting to succeed bring their child into the partnership so that then they get drawings and they're really involved in management decisions and likewise of tax planning, which I'll discuss a tiny bit later. That's helpful. So a key take-home message is that, and this is something that we see all the time, is families are reluctant to put anything in formal writing whilst they're on good terms. They don't think it's necessary. They don't want to rock the boat. They don't want to cause any awkwardness. But actually, it's so much better to be safe than sorry. The amount of times that we see partnerships between the families where the whole relationship has unfortunately become sour and there is no written partnership agreement, and that's when things really begin to get difficult, because unless parties can agree for a mutual ending, then it does fall to the Act, which then provides not the greatest resolution for all parties. So it really is important that everyone knows right from the beginning where they stand and what's to be expected, and just gets a partnership agreement drawn up. It's never too late. So even now, if you have an unwritten agreement and you think, actually, I want to get it put in writing, but can that be possible? Yes, it absolutely can be possible. It's never too late to get it in writing. And in fact, it's better to do it sooner than later whilst everyone is in agreement. So that really is my key take-home message. So I hope you find that helpful. And yeah, we'll talk through some questions now. Thank you.
Adriana, thanks so much. Clearly, quite a lot to think about there, and yeah, you've given me the opportunity to ask you just a few quick questions. So let's talk about a scenario where we are ready for a partnership, but we've got no written agreement in place. Should we now put one in writing? And what are the pros and cons of having a written agreement?
Thank you, George. Yes, absolutely. Always best to have a written partnership agreement, as I just said, that it's just so much safer. It just allows parties to know exactly where they stand and what is expected of them. Some pros are that it provides far more structure when people work alongside each other without there being any uncertainty of what each person should be doing or isn't doing. The agreement will show exactly those roles. It allows for all parties to have a mutual benefit. So by getting what they want, for example, do they want tax benefit versus return on income? It provides essential details such as what happens if parties fall out. It may seem at the time that that's never going to happen, but unfortunately, things do take a turn when least expected, and it's much safer to just have this safety net of knowing that that can all be resolved and hopefully more amicably. It also encourages parties to reinvest in the business, which in turn will provide more within the capital account, which is in everyone's best interest. It promotes parties to regularly communicate and be up to date, which is really important to make a business successful, because we often hear families just don't communicate. And when you've got a written partnership agreement, not only do families have to communicate on the offset to really decide and hone in what's in the best interest of both the business and the parties, it also means that actually you can pencil in to have regular strategic and operational meetings going forward, which will then help keep communication within the family going, which is really in the best interest of everyone. And unwritten agreements allow any partner to give any partner can give notice and leave the partnership, which effectively ends the partnership. Whereas a written agreement doesn't allow that. So that's another pro, is that you don't have to end the entire partnership if one person wants to leave. And another thing within the unwritten partnership is that a partner cannot be removed unless there is this express agreement from all the partners, including the one that is intended to be removed. So that could be a real problem if one of the partners breaches the agreement. So there are lots of pros to having a written partnership agreement. The cons of not having one is, in my eyes, quite few, but I will list them. So going back to communication, I guess some people may see having a written partnership as a con because parties will have to communicate right from the start. And this can mean having those difficult or awkward conversations, which some families are not willing to try. Parties cannot just bury their heads in the sand and not think about the future and what that should look like for all partnership members. They do actually have to think about these things, which I know a lot of people do find awkward. And then lastly, unlike an unwritten partnership agreement, which costs nothing to set up, a written partnership agreement should be carried out by a good agricultural solicitor, which will inevitably cost money. So that is another con. However, I do see that as a pro, because it's investing in something which is well worth it, but people might see that as a con.
Thanks for that. So a classic situation, which you sort of described in your opening remarks. So I'm part of a family partnership, but now we don't agree on all we want. We don't want to farm together anymore. Some people have put in more money than others, and the partnership has had use of lots of differently owned assets and farmed the holding, which is tenanted. How can we now dissolve this and so that everyone gets their fair share?
Thank you for this question. And this is one I always dread when I answer the phone, because I'm assuming in this situation that it is unwritten, because if it was written, these questions wouldn't be asked. So I'll just caveat by saying the answer does depend on whether the partnership is written or not. But assuming it's unwritten, an unwritten agreement is just about satisfactory if parties are in harmony. But when parties come unstuck, and they don't get on, and the partnership is unwritten, this is when, as we've detailed above, it is really tricky. As the agreement is unwritten, the only way to formally resolve matters is by way of utilising the Partnership Act 1890. However, crucially, under the Partnership Act, the default rule is that partners are entitled to share equally in the capital of the business. Therefore, if the property is owned by one partner, that then becomes a partnership asset and therefore capital of the business, then the default rule is that each of the partners are automatically acquire an equal share in that property. And this could cause a huge problem if one person has bought in more assets than others, as they will not necessarily get their fair share when the partnership is dissolved. And as you mentioned in the question, the holding is tenanted, and that is likely that there would be a sole tenant only. And yet the tenanted holding has been farmed by the partnership as a whole, which means that the tenant could find now that their farm is a partnership asset with equal shares between all of the parties. And this could therefore mean that the tenant, who cannot give up occupation to other parties upon the dissolution, may find themselves having to provide monetary value for the share in the holding to the parties as a way of accommodation. And this is going to be compensation, sorry. And this is going to be problematic if, for example, the tenant was particularly cash poor. They might find that they're not actually able to find those funds. The best situation is obviously to have a written partnership agreement where the tenancy was specifically not listed as a partnership asset. And the best way of resolving the above would be actually, instead of relying on the Act, if can be, to agree to a mediation. where a mediator can help parties work through the best solution, rather than having to rely on the Act, which will clearly not be in the best interest of all parties. And mediation is actually a really powerful tool that can be used to bring the most of broken relationships together to work towards a mutually beneficial outcome. So I think the key things here is that if an unwritten partnership agreement is in place, then unfortunately the assets will likely, if they're all used by the partners, they will all be partnership assets, including the tenant holding. And in order to dissolve this and everyone get their fair share, the best way is for mediation. And it might be therefore that you can actually mediate to find the best solution, or even move to getting a written partnership agreement first. But if that's not possible, then it will fall to the Act. Thank you.
Okay, Adriana, I have lots of other questions, but we are out of time for today, so we're going to have to leave it there for now. So those of you who have got more questions like me, why don't you become a member of the TFA if you're not one already? Currently, membership starts from just £299 per year, so it is excellent value for money. It gives you access to dedicated advice, information, and support from experts like Adriana. So for more information about the TFA and how we support all farmers in England and Wales who don't own the land that they use for farming, why don't you visit our website, www.tfa.org.uk, and there you can find information about our upcoming calendar of events, as well as the latest news affecting your sector. So we hope you found this teaching video useful. And if you're watching this on YouTube, it does form part of our growing YouTube library. So let us know in the comments below what you thought about this little video. And don't forget to like and subscribe to the channel so you don't miss out on other content as we post it. So many thanks again to Roy Thorns for sponsoring our virtual program of teachings this year. And thanks again to Adriana for her input. Thank you and goodbye.